Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is John Roberti, and today's program is True Crime, an investigation into DOJ's recent policy change on criminal monopolization prosecutions. Deciding what crimes should be prosecuted, specifically what antitrust crimes should be prosecuted, is a complicated process. Prosecuting something criminally really impacts the liberty of individuals as well as corporations in a way that a civil prosecution doesn't. So moving conduct that previously was viewed as civil into the criminal bucket is very, very impactful. Today, we're going to talk to a couple of experts who have thought a lot about a recent DOJ announcement that monopolization claims that really haven't been prosecuted criminally in 50 years, are now going to be subject to potential criminal prosecution. My co-host today is Jaclyn Phillips. Hi, Jaclyn.
Hey, John.
Jaclyn, what are we doing today?
So today, like you said, we are jumping into the wild and uncertain world of potential criminal enforcement of Section 2 of the Sherman Act. I'm excited to welcome two guests to the show today. We have Tiffany Ryder, who is a partner at Axinn. Tiffany's practice, among other things, focuses on criminal antitrust cartel investigations, follow-on civil litigations, and designing and implementing global competition compliance programs. We're also joined by James Hunsberger. James is counsel at Axinn, and his practice focuses on all things antitrust, from mergers to criminal investigations to antitrust counseling. James and Tiffany have been studying what the DOJ's recent statements on criminal enforcement might mean in practice and what we can glean, if anything, from the past. They were quick to get on an alert on this topic and are the authors of a forthcoming article that will cover this issue in depth. So welcome to the show, James and Tiffany.
Thanks for having us.
Absolutely. Great to be here.
Awesome. So to set the stage and get us started, criminal enforcement of Section 2 is a fairly new topic of conversation in the antitrust world. We've really started thinking and talking about this in the past couple of months. So Tiffany, I know that you kind of had a front row seat to where this discussion all began. So can you set the stage for us and let us know why we are talking about this today?
Yes, I did. It definitely surprised me and continues, I have to admit, to baffle me slightly. So we'll try to get into this area as best we can. But I was at the White Collar Conference, the ABA White Collar Conference in San Francisco a few weeks ago, and I was on a panel with Richard Powers, the current criminal DAG, and he, to a question asking about Jonathan Cantor using all tools available, he responded that they were thinking about criminally prosecuting Section 2, monopolization claims. And under the right facts and circumstances, they would bring that. Now, this is quite a shock because they haven't done this for like 50 years. And in the recent history, starting back 20 or 30 years ago, the DOJ, instead of sort of being more ambiguous, was getting more and more specific, saying we will only prosecute that which is, unredeemable whatsoever, has no positive benefits whatsoever. So classifying things as per se and sticking with criminal in a very narrow set of cases that could be, this is price fixing, market allocation, bid rigging, and clear and unambiguous what would be criminal. So it's really shocking when he said on the panel that they would be doing this, and it's, to which I think I very quickly, and we've dug into these a lot more closely now, but quickly brought up a constitutional issue that it could be there, wondering what the facts and circumstances would be like. And honestly, sort of glibly said, I would be very curious how leniency would work in that situation. So it brings a lot of questions. I think we have a lot more questions than answers.
It seems that way. And that was back in March, I believe. So since we heard that statement, has DOJ said anything more about their plans with criminal enforcement and what types of criminal enforcement under Section 2 we might be looking at? Have there been any additional statements?
There have been, Jaclyn, and it's interesting, as Tiffany mentioned, the remarks from Powers were a bit more in response to a question, not a formal statement or a formal speech, but he was very clearly prepared to give that answer. But if there were any doubts as to whether this is an official policy change by the DOJ, I think those doubts are eliminated now, because in several policy statements since then, Jonathan Cantor, for example, the Assistant Attorney General in the Antitrust Division, gave opening remarks at the Spring Enforcers Summit right before the ABA Spring meeting, and he made very clear that the DOJ intends to aggressively pursue enforcement of the criminal antitrust laws and specifically called out monopolization. And he echoed some of the same points that Richard Powers made in saying that when Congress passed the Sherman Act, it made both Section 1 and Section 2 crimes, and more recently, Congress has made those felonies. And sort of, again, emphasize, if the facts and the law lead us to the conclusion that criminal prosecution is appropriate, we will not hesitate to do so. As you might imagine, this has led to, as Tiffany alluded to, a lot of questions among the antitrust bar, a lot of chatter, a lot of discussions related to what could these possible cases be that the DOJ might bring. And so at the ABA Spring meeting on the Enforcers Roundtable, the ABA chair, Jonathan Jaclyn, who was co-moderating the panel, asked Cantor and said, what is your guidance for practitioners, for the antitrust bar on what Section 2 criminal enforcement might look like? And Jonathan Cantor said, my guidance for you is to read the cases. And he said there's over a century of case law relating to criminal antitrust enforcement of Section 1 and Section 2, so go read the cases. And on another panel, I think a day or two before, Richard Powers said something similar and said, there's a long history of these criminal cases, and so I suggest that you go take a look at what's on the books. There was no further guidance or clarity, no reference to any particular cases or any specific facts that might warrant criminal prosecution, so it was sort of that high-level guidance of go read the cases.
So that there probably is a century worth of cases, but that century ended 50 years ago.
Yes, it did. And I want to point out also, there's a big difference between looking at, these cases and, what is actually practical now in a sense. It's in the last 50 years, there's been a lot of clarity and narrowing and hearkening back to these cases. And we'll talk a little bit about these. But these aren't the type of things that it seems easily to analogize to at this point.
I think we've all read a lot of cases, probably between the four of us, a good amount. None immediately come to my mind when you mention, going back to read the cases. And like you said, I think when we, antitrust practitioners and our clients, when you think of criminal enforcement, you think of Section 1, you think of price fixing. So what cases are we talking about? Can you illuminate that for us?
Yeah, so we went back, and there were 11 cases in the 1970s. There were a few of these, the most notably Empire Gas and Dunham Concrete. Dunham Concrete is the one that is near and dear to my heart now, cracks me up. So we'll tell you a little bit about that one. And then there were a couple other cases too. Braniff Airlines. These are cases that really sort of intermixed. It was more an attempted conspiracy to monopolize. It really was sort of a Section 1 case that was brought. There was an agreement between parties. It really fit more into the Section 1 category. But these other as well, all of those cases were brought both Section 1 and Section 2. So it sort of begs the question, was Section 2, would it be even necessary if there were a case that was similar to this? But when you look at both Empire Gas and Dunham Concrete, these are like mob-like cases. This is activity that is more appropriately prosecuted under RICO. So it sort of we were scratching our head saying, wonder why this wasn't brought under RICO. Well, it predated RICO. So I guess they were searching for something there. And so they got to this. I mean, so Dunham Concrete, it's an associate of Jimmy Hoffa. It's the gentleman who, in fact, testified against Jimmy Hoffa in his jury tampering prosecution in the 1960s, who then made friends with Ted Dunham. And he then hired another gentleman, Teamster associate, and they took what's considered in the newspapers like a goon squad, 30 to 40 men with chains and pipes to a construction site that was using a different concrete pipe in the construction, and decided to beat on the construction site and, unfortunately, the people that were there, and intimidated, assault, destruction of property, all these. They even took a shotgun and also shot up the site. And it was noted in one of the opinions that they had actually considered taking a machine gun, but that on advice of counsel, they did not take the machine gun. I'm not clear if the counsel recommended they change to a shotgun or whether they just simply, the counsel said, no machine gun. So then they're like, okay, that's out. I guess we have to take the shotgun now.
I guess that's privileged advice.
Yeah.
Tiffany, as you describe those cases, it doesn't sound like antitrust was really the primary crime.
It does not.
So you talked a little bit about a constitutional issue earlier. What do you mean by that?
I think there are a couple different angles to come at it from a constitutional perspective. We would certainly expect that defendants in any future Section 2 criminal prosecutions to raise significant due process objections, primarily due to the lack of fair notice on what conduct constitutes a criminal violation of Section 2. And, the Supreme Court law is clear that in order to satisfy due process, criminal statutes need to give sort of an ordinary person a sense of what conduct is prohibited. And so here we would expect potential defendants in any Section 2 case to say that this sudden criminal enforcement after a near 50-year break in criminal enforcement violates due process, and to argue that the theoretical ability under the statute for DOJ to bring criminal charges without actual prosecutions is not enough fair notice to put defendants on notice of what is and is not illegal. In addition, if the DOJ were to seek to bring a Section 2 claim where the presumptive rule is that the rule of reason applies, the very nature of the rule of reason inquiry, we think, which involves a careful balancing of the anti-competitive effects and the pro-competitive benefits, may raise fair notice or void for vagueness type issues. As we all know, the Supreme Court very rarely hears these types of antitrust cases, let alone cases involving a full application of the rule of reason. So a defendant might argue that there's not enough definiteness in the law and in the practice of the DOJ prosecutions that to put defendants on fair notice on what is and what isn't illegal. Notably, as a listener of our Curious Amalgam, going back a couple episodes to the Justice Breyer episode, in his dissent in Legion, he even noted that when certain conduct is subject to the rule of reason as opposed to per se, that it might hinder prosecutions because it may not be fair to put defendants on notice of what is and what is not prohibited.
So I want to add in too, when the DOJ decided to prosecute no poach criminally, they came out and they said, this is the guidance. We're going to do this going forward. You are now on notice, and we're clear about what they intended to do. And they've even faced constitutional challenges, even with that guidance being put out. Here we're in a situation where they're almost purposefully saying, this is an announcement that's not an announcement. Yeah, go look at it. We've always been able to do it. It's maybe what? Because they say it's not new, that then they can say, oh, this is not new, and therefore we can prosecute something that has already been existing. But I think it really puts them in a situation where they've in fact not put out enough guidance to be noticed. I get that it was used against them in the no poach cases. If you look at DaVita and the arguments that were made there, the fact that they came out with guidance in 2016 was a way to point at, see, there's the cutoff. And in fact, see, they're saying it's something new. And DOJ had to then come back and say, no, actually, it's just like market allocation. It, in fact, is something that we already have. So I can sort of see the strategy of saying, oh, it's always been this way. We can do this. But it leaves us in this world, whereas we have, as antitrust attorneys, we who practice criminal antitrust are still not sure exactly. So how could this pass the test of an average person understanding what's criminal and what's not?
And what do you imagine? I was thinking about the 2016 guidance when you were talking about this, and how that, in theory did put the public on notice of what DOJ was thinking. Given that, it sounds like, obviously none of us have a crystal ball, but that we wouldn't necessarily expect something like that with criminal monopolization enforcement.
I sort of expected that if they were really going to bring a case, they would do something similar to what they did in 2016. The fact that they're going this route, I think it'd be a big gamble to actually bring a case. However, could you use the leverage sooner? If you take this position and you're not actually going to take it before a judge, but you're going to talk to people who you think are violating Section 2 and threaten to bring cases, maybe you've set yourself up to be in a better position to do it sooner with the unknown. I mean, who wants to really risk it? And so maybe it's something where they want to leverage it in the short term, rather than actually lay it down and go for it in the long term with actual cases being brought. I mean, this is me, of course, just guessing. So I have no idea, though.
Yeah, I mean, it sounds like all we can really do is a bit of guessing right now. And what do you think DOJ's, kind of current enforcement prioritization and, the successes or lack of successes they've been having, in the courts plays into this, if at all?
Yeah, I mean, I think that they are definitely reaching for tools to look at a number of markets that they find challenging. And I don't think, I think this sort of goes hand in hand with being aggressive. So I think it does, But as far as I can tell, I do not think that they are being deterred by any of the challenges they're facing, whether in the bid rigging, the poultry case, up for number 3, or in the first wage fixing and first no poach cases. I mean, these are, all of these cases, though, are different facts and circumstances. So you don't know what's sort of up next for them. I don't think it necessarily means that they wouldn't be able to bring something successful here. It's not like the facts of one case do not necessarily play into the facts of another. It may set aside sort of redoing the same trial, but normally doesn't affect it. So I think that they stay on their aggressive path at this point in time.
To your question, Jaclyn, it does seem that DOJ in general does not deter. I think in a recent speech, Jonathan Cantor suggested that prosecutors not back down and listen to Tom Petty and use that as motivation. But it does seem that if you're trying to be more aggressive and bring more aggressive cases, the Section 2 area is an area that presents some real difficulties. As a threshold matter, the rule of reason applies. And since these older cases from the 70s, antitrust law has sort of made a significant shift towards a full-blown rule of reason analysis, carefully balancing the anti-competitive effects, the pro-competitive benefits, and sort of this highly fact-intensive inquiry. And that fundamental framework for analysis has continued to evolve over the last several decades. Well, after these cases were brought, and it just seems hard to win a case beyond a reasonable doubt, prove the elements of a Section 2 claim, whether it's a monopolization, attempted monopolization, conspiracy to monopolize, beyond a reasonable doubt. The rule of reason and the balancing of effects inherently involve some level of reasonable doubt. And these cases, as we've seen in history, are very tough to win, even on a civil preponderance of the evidence type standard. So you can imagine, for example, in a monopolization claim, you look at the elements, the first being monopoly power. And that question is sort of two PhD economists, often both with a Nobel Prize on each side, arguing that, of course, the defendant has monopoly power and can exercise that power in these markets. And then on the other side, you have someone saying the complete opposite. And it's just hard to imagine that there wouldn't be some level of reasonable doubt on that element. And then to the same effect, the second element, the anti-competitive or exclusionary conduct element, it's hard to imagine that there also wouldn't be reasonable doubt there. That's one of the areas that the Supreme Court, lower courts have struggled with for years, is defining the line between intensely competitive conduct that the antitrust laws are intended to promote and anti-competitive conduct that we should forbid as unlawful under the antitrust laws. So given the difficulty of proving both of those beyond a reasonable doubt, it does seem like a lot for the DOJ to take on here. But to Tiffany's point, of course, every case is fact and circumstance specific, and they could find the right set of facts to bring a case. It's just, we're all scratching our heads a bit trying to figure out what those facts might be.
How does the concept of mens rea play in here?
Well, it's interesting. So, generally in a criminal prosecution on Section 1, it is just the intent to have made the agreement and a general intent. We saw that in DeVita, there was a bit of a higher bar, as the judge said they needed to prove that there was an intent to allocate the market, which wasn't exactly consistent with what we've had in criminal prosecution. They have, as far as I can sort of tell, there have been some revisions to the manual that it used to have sort of internal policy. What do we criminally prosecute? And it used to have things like something, that is generally secret. That's been removed. So it does seem like, and I don't know if that's sort of a no poach thing, because a lot of people are ignorant of whether no poach is a violation. So I think the cases that we're seeing coming, a lot of people, it used to be in like the price fixing or the bid rigging, it was like a smoke filled room and people knew like, let's get the burner phone and let's not tell anyone. And I think I'd get in trouble if anyone knew, but they don't always know for no poach. And I doubt they would know, since we don't seem to know for this, Section 2. So it is, I think it would be interesting to see what they would do with that. I mean, it just seems to go in an opposite. It is a pendulum swinging the other direction than what we've got.
So I could imagine some Section 2 cases. Let me run a couple by you and just get your reaction to them. I mean, the Shukeli, the Farmer Borough case, now that was prosecuted under different statutes, but that seems like the type of conduct where you have somebody who acted unilaterally and as a result raised prices 8,000% in an improper way. Would that be something? I mean, do you think that would be the type of case the DOJ could bring?
I mean, I think the DOJ always it's appealing for a jury if you've got someone who is a bad actor. It can be painted as a bad actor. I'm not sure if it's always necessary for the criminal elements of it. And so I'm still not sure, even if someone is a bad actor, that they would know that would violate Section 2. And I think if it is something that they are a bad actor, if we're going to go back to our Dunham Concrete, or if you're talking about Farmer Bro, any of those things, there are other tools to use rather than Section 2. I try to imagine, what does it gain them? Like a big risk to bring a Section 2 case. So what would be the facts and circumstances that would be, on balance, I'm going to take this risk because I want to right this wrong. I want to bring this case. And I have a hard time figuring out what you can't do with all of our other tools that you need to bring Section 2 as criminal.
And again, I'll just throw out another one that I've been thinking about. What about a really rough Walker process claim where somebody's committed an egregious fraud on the patent office, as a result has gotten a patent that essentially confers monopoly power on them improperly, and as a result excludes competition, raises prices, et cetera. And I mean, just for the sake of argument, let's assume that you could prove that it truly was fraud on the patent office. They knew they didn't have a right to get the patent. Is that something you'd want to? I don't see how you could prosecute that as a Section 1 claim. So is that something you'd want to prosecute criminally? So,
John, you had me at egregious fraud. I'm still looking for it. I don't know, James, what you think of that one?
Yeah, it still seems tough because you'd still have to establish a relevant market where there is clear monopoly power, and you'd have to establish clear anti-competitive effects, and there's again, both beyond a reasonable doubt, and there are instances in which Walker process type claims still fail in the civil realm. So they're not always successful with a civil standard of proof, and you add the criminal standard of proof, just seems hard to get there. But you can theorize, you can stylize a set of facts, and maybe get to a place where you might envision such a claim.
All right. Well, stay tuned. This is, I think, an issue that we will see developing over time, and we would love to have you back as these cases develop. But let's move on. And Tiffany, let me start with you. Tell us something interesting about yourself that we wouldn't know if we only knew you professionally.
So I worked on the Roseanne show. So this was when it was number one sitcom in the early 1990s. I was in school at UCLA, theater major, and I got a job as a set designer. And so it was her season where she was a waitress with a juniors department store. That was my set. And then I decided to leave Hollywood.
Did you put any like Easter eggs in your set? Like if we look really hard at that, we could freeze that frame and look really hard. Is there something that we would find?
So I designed the menu. And it was, I recall now, it was on blue paper. You don't want any colors that are too hot on television cameras back then. And I do remember making up, the menu. It was a fun little side that, no one could probably ever read from the distance where the camera is.
But you had come up with all the dishes and
yes.
Did you have to go a step further and come up with the recipes, or just the description?
Just the description. But it was also fun. I went to the restaurant supply stores and bought everything for like the cafe. I went to the garment district in LA with a fanny pack full of thousands of dollars to purchase all of the clothes. And I bought them off the back of trucks for cash.
And again, I think that might be where we find this criminal Section 2 claim, and buying stuff off of the back of trucks. But all right, James, what about you? Tell us something interesting about yourself that we wouldn't know if we only knew you professionally, and does not involve either Roseanne Barr or Tom Arnold.
Well, that is a tough one to follow, I have to say. And as a regular listener, I knew this question was coming, but I still struggled to come up with something. So I'll go with one that's both sports and family related. So I'm a diehard Buffalo Bills fan, to the point that earlier this year, when the Bills looked like a real Super Bowl contender, I negotiated a Bills-related compromise with my wife related to our firstborn child, which we're expecting later this year. I was somehow able to get my wife to agree that if the Bills won the Super Bowl this year, we would be able to name our baby boy Josh Allen Hunsberger in honor of the Bills' superstar quarterback. But as is not surprising for a franchise that lost 4 straight Super Bowls in the 1990s and then had an almost 20-year playoff drought, the Bills did not win the Super Bowl. Instead, they lost in heartbreaking, dramatic fashion to the Kansas City Chiefs. So, unfortunately, I lost the opportunity to name him Josh Allen. We have not yet settled on a name for our baby boy, but just the latest in a string of heartbreaks as a Bills fan.
And for our listeners, I just wanted to point out that James's wife is actually one of my best friends and college roommate, and I don't know that she would have followed through on that bet. So I'm glad we don't have to see that through. But sorry, James.
James, and I'm not trying to give you any advice here, but did you just think about going with, what about Bill?
Bill Hunsberger.
Yeah, Bill.
What about Buffalo Bill? Buffalo Bill?
Or yeah, Bill S. Hunsberger.
Veto on Elisa's behalf.
John, do not encourage him.
The other thing is, again, I'm not your mentor or anything, but sometimes you want to not necessarily ask permission. Ask for forgiveness later. Yeah, I just love the name Joshua Allen.
I like that principle in general, but I don't know if it applies here.
Okay. I understand. And then my last bit of little advice is, listen, don't ask anybody what they think your kid's name should be from experience, because I don't really care. James, I like you, but I don't really care if, Jonah was the kid who beat you up in 3rd grade. I'm going to name my kid Jonah, whether you like it or not. And I don't need your input on that.
Excellent advice.
Yeah. Okay. Well, with that advice, let's go to our final segment, the Curious Hat.
And now it's time for the Curious Hat.
Okay. Sometimes if we are in person together, we have a hat, but we don't have a hat. I have a list of questions, and theirs are numbered from 1 to 25. And so I'm going to ask each of you a question that corresponds to a number that you pick. So, James, why don't you go first? Pick a number between 1 and 25.
I'll go with number 17 for Josh Allen.
Okay. Number 17. What was your favorite course in college, law school, or graduate school?
Ooh, that's a good one. I can't say antitrust law because that would just be too predictable. So I will go with, I took an advanced constitutional law seminar in law school at Georgetown, where we had people across the full range of spectrum of ideas and arguments and constitutional interpretation methodologies, and sort of had some full-throated debates about the proper way of doing constitutional law. And we each would write a paper each week on a key issue, and then we'd argue about it the following week. And just enjoyed that type of spirited debate with colleagues that you may have a different view than, but you respect their views and have a nice intellectual debate.
Did you get an A in that class?
I did, I think.
James got an A in almost every class. Spoiler alert.
Okay, you had a very different experience than me in law school then. Tiffany, how about you? Number from 1 to 17.
Number 3.
Okay. Number 3. What is your favorite vacation destination?
Ooh, I am going to have to go with Antigua. We've been a couple times, and I went looking actually on VRBO. Or I guess some people call it Verbo. I don't know. But we're looking for a place, and it's right on the beach. It has it's a nice little villa, but it's part of a community, so my kids can go and they can borrow a sailboat and go out in the bay and have a great time. In fact, though, when I was researching it, it was one villa over from, and I don't watch it, but it was a villa that was used on The Bachelorette a couple years back. That one has a private pool. Ours does not. So I thought it was pretty funny. We were staying next to the Bachelorette season finale or something.
And who really hasn't stayed next to a Bachelorette place? All right, and thank you for joining us. We will see you next time on our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.